sorry, this sum of money is being held. It's already being held. It's already in the bank account. Now, the decree holder, also known as the judgment creditor, is the one, he knows, that this amount of money is in the bank account on behalf of the judgment debtor. So there's no need to put it on in an account or so, because the property is already with that person. The cash is already with that person. In that, or the sum of money is already with that person. So there's no need to put it because it's already there. What the court is just doing is saying, okay, this is a garnishee application. So this is what happens. You brought this application, look at the merit of the application, and it says that it's merited. So what they do is they move forward and make an order that sum not to go to the judgment debtor, but should be released to you, because it cannot just be released. So they make a garnishee proceeding. They will make an garnishee application, the court to order for the funds to be released to you, the judgment creditor or the decree holder.
Okay. All right.
Yeah.
All right. So maybe just one last question, so that I also give my other colleagues an opportunity to be asked the questions. So would the garnishee proceedings be instituted where judgment has already been issued, and then the judgment debtor for some reasons has gone to court, maybe to maybe for the court maybe to stay, not actually stay, but to maybe what can I call it? Maybe to reverse the decision that you had already made against the judgment debtor.
All right. Okay, so you see, the only way a judgment debtor can reverse a decision that has already been made is if he appeals. And an appeal doesn't act as an automatic. It doesn't act as an automatic stay. You have to go seek for a stay of execution in the court. You can go either to the court, to the higher court, or you can go to the court that gave the judgment the first place. So it doesn't act as an automatic stay. What will happen is this guy has to appeal. So a garnishee application is done after the judgment has been given. Because you become a decree holder or you become a judgment creditor after judgment has been given and you have extracted a decree from that judgment. So that's the stage where garnishee applications come after judgment has been given. Because what you're going in a garnishee application, what you're basically saying is that this property or this sum is being held on behalf of the judgment debtor, the person who's lost the case, and we want you to give it to. We're requesting or praying to the court to release the funds to us, the judgment creditors, or the decree holders. Yes.
All right. Okay. I have had instances where the court, maybe someone is doing an appeal, and then the court says that, well, it is okay, you can do the appeal, but then since we want to be sure that you have maybe that amount of money, maybe the advocate of the judgment debtor and the advocate of the judgment creditor, you open an account, and then for you to deposit, maybe say that the creditor was awarded maybe 2 million, but then the court directs for me to maybe even hear and determine your appeal. I want you to talk to the counsel for the judgment debtor and the counsel for the judgment creditor. You open a joint account, and then for the judgment debtor to deposit that amount of money, the amount of money that was awarded to the judgment creditor. So then, in that instance, would that also the garnishee proceedings also be instituted in such instances where you are very, very sure there is amount of money in the account?
Oh, thank you for that. What you're giving, the example you're giving is it's a valid question. Now, the example you're giving is totally different from garnishee applications, yeah? Because what you're saying is security. When you're appealing, you have to give some form of security. The court will order that you give some form of security, some form of security for cost. You can check order 42 of the civil procedure rules on that. So that's a security. You're making, the court is saying, okay, what we will do is, okay, this is what happens. You've won a case, you've lost a case. You want to appeal that case. According to the law, if you read the civil procedure rules, and even also when you read the Court of Appeal rules, Rule 5.2, it says that an appeal does not act as an automatic stay. Meaning, if you don't look for a stay of execution, what will happen is this person will execute against you. Why will they execute? Because you've appealed, but you don't have any stay. They will continue executing. So you have to go to seek for stay of execution so that this judgment or this decree isn't executed. This judgment creditor won't come after you and tell you to pay these amounts of money. So the court will say, as condition for us to stay these, proceedings, or to stay, to give you a stay of execution, we want you to deposit a certain sum in court, or maybe in a fixed deposit account. That is an order for security for, that's not what we call it's an order for security, like it's an order for security for cost for the appeal.
Okay.
So those are two different things from the garnishee application. Garnishee is only there, like you just say, what we want is this money is being held by these people on behalf of the judgment debtor, pay it to us.
Okay, thank you. Thank you.
Yes, yes.
Before we invite Arunga Michael, I think his hand has been up, and Alex
yes.
To take to the floor. I'd like just in a minute to answer a question that Gesheru wasn't able to respond to. So the reason why the matter was dismissed from the Employment, Travel and Labor Relations Code is because of want of jurisdiction. So remember, this is a retiree. He is not employed. So employment matters are people who are still within their employment setup, or perhaps their contracts have been terminated arbitrarily or everything. So for retirement matters is what we call the Retirement Benefits Authority. This is an indoor mechanism for dispute resolution. So if this guy wasn't satisfied with the decision by the Retirement Benefits Authority, then he'll move to appeal at the Retirement Benefits Appeal Tribunal. So the decision of this tribunal is final. So that's where you, as a new advocate, is supposed to appeal the matter if the indoor mechanism wasn't exhausted. So I hope that's the point is home, Gesheru.
Thank you very much for that.
Great, you did well, and I expect a 9 Ps from you at the end of the bar exams next year.
Amen. Thank you.
Yeah, you're really impressed. I like your confidence. So I'd give you very high marks, very high marks. So let's go to Michael Arunga, and Alex, please take the floor with Alex, Michael Arunga. So please go on, Alex.
Hi, Michael.
Hi. Sorry, just before you baptize me by fire, I have a question.
Okay.
Yes, I have a question concerning the garnishee proceedings.
Okay.
After the court has issued the garnishee nisi, in terms of enforcement, what happens if this third party defaults to comply with the court order?
Okay. When they default, can you hear me? When they default is usually that's contempt of court. So you have to comply with the court order. Like Solonka said, the issue usually is I have won the case against, let's say you, Michael, and I know Equity Bank I have won a case against you for 10 million shillings. I know Equity Bank has 10 million shillings that belongs to you, that Equity Banks maintain an account for you, and it has 10 million. So because I've won the case, I will start an garnishee application against Equity Bank, claiming that Equity Banks give me the 10 million shillings that belongs to you, and the court will give me an order to go and serve Equity Bank and tell Equity Bank, this guy has my debt from the judgment of the court, and the court has told you to give me the money that belongs to him. If I go to Equity Bank and Equity Bank gives him the money, they refuse to give me the money, then that's contempt of court because Equity Bank has violated a court order. Simple. Have you understood?
Okay. Yes, I've understood. But just a follow-up. I think I'd seen that the Contempt of Court Act was declared to be unconstitutional. So do you move the court under Order 51 on the normal applications, or what, or under which law now should you move the court?
When you look at Section 5 of you see the courts have said since the Contempt of Court Act was declared unconstitutional, we revert back to the previous position. Before the Contempt of Court Act was enacted, the law which used to govern contempt of court was the Judicature Act. When you look at Section 5, it provides for contempt of court. So in any case, you use that provision to institute contempt of court proceedings against the Equity Bank and its managers.
Maybe to add on that, Arunga, if you look at when the Contempt of Court Act was declared unconstitutional, there is this thing. The Contempt of Court had expressly repealed Section 5 of the Judicature Act, the one that Alex is refusing. The one that Alex is talking about, the Judicature Act, Section 5. So what happens is, if it was declared unconstitutional, then it means Section 5 of the Judicature Act will still be in force. And that is why you will seek recourse in the Judicature Act, that specific provision, Section 5, which provided for contempt of court. And it says that you revert to, if I can remember well, there are some laws, I don't know if it's English laws, there's some type of legal provisions that you will revert on, some old English statutes or so on contempt of court. Is that clear?
Yes. Yeah.
Yes. Thank you.
Yes, Section 5 refers to the existing law in England. Actually, in the firm that I'm working at, we have done an issue about that. The same. Section 5 says simply that if a person commits or does something which is contemptuous, the law applicable would be the law applicable in England at the current time. So you go to England today and you look at which law governs. I think the latest law was drafted in 2012. So that is the law which will be using, which the court will use to punish this person for contempt. But the Kenyan provision which refers to the law of England is Section 5 of the Judicature Act. Section 5 of the Judicature Act, sorry. So can you continue?
So, Alex, now you can baptize him with fire now. You added baptism with fire.
Okay, I will have a convincing question and probably a civil question. The questions that I'll ask you are questions which I remember were asked last year to some of my colleagues during oral. So I think it's a fair chance for you to gauge yourself if you are before those panels, how would you have performed? The first question would be, can you give me at least just 3 ways in which a person can acquire title to land? 3 ways in which a person can acquire title to land.
Sorry, come again.
3 ways in which a person can acquire title to land. Okay,
thank you. First of all, I think a person can acquire title to land by way of sale and transfer. Then another way one can acquire is through public auction. And then third one, I think one can acquire through a sublease. Thank you.
Okay, thank you for your response. The second question will be, it's a scenario question. Assuming that I assume you have gone to Kenya School of Law. Kenya School of Law has a very big land. Assuming there is a man who came to Kenya School of Law 25 years ago. They built a house at the corner of the school. They married, they have had children, they have lived on that land for the last 25 years. Last week, the director of the Kenya School of Law told this guy to get out of the school's land, that they don't want to see them there. Does this person has a remedy in law?
First of all, I think this guy has a remedy in law. My reason, the reason to support my answer will be going by the Mitubel case in the Supreme Court. I think the Supreme Court said that such people who are staying on public land have a right to enjoy the right to housing under the Constitution. Therefore, they can claim for compensation from the government. Kenya School of Law being a public land. Yeah, thank you.
Okay, the third question. Assuming that this person goes to court and says that the court should give them a title to that land because they've lived there for so many years, do they have a right to be given that title to land?
Okay, thank you again. I believe the question you've asked is on issues to do with adverse possession. So you cannot claim adverse possession on public land. So therefore, this person does not have a recourse in terms of claiming title. Thank you.
Okay, finally, what do you understand by the phrase competence?
Okay, competence to me means that where there's a clause, in an agreement, especially an arbitration agreement, where there's a clause that does not where there's a clause that goes against part of the agreement, then they'll consider that part to be separate and uphold the rest of the clauses in the agreement. Thank you.
Okay, thank you. I don't know whether I should give him my response right now or you can ask some questions. Solonka.
Okay, no problem. Sorry. Sorry. Okay, Arunga, I only have one question for you. Mr. I see your 10 minutes are up, and Mr. Alex Mwendia has asked questions substantively. So my only question will be, what are the different types of companies? Give me a few different types of companies that you know.
Sorry, you've said how many?
Any number, exhaust as much as you can. Just give me any.
Okay, I know there are two types. There are two types of company: public company and private company.
Okay, what's the difference between a public company and a private company?
Okay, a public company. You can in a public company you can sell shares to the public, while in a private company you cannot sell shares to the company.
Okay.
Also, yeah. Also, a public company does not have a share capital. Yet, some private companies have share capital. Thank you.
Okay, no problem. Thank you for that. Now, I'll make the last question. What is the difference between a company that is limited by shares and a company that is limited by guarantee?
Okay, a company that is limited by shares, one, has a share capital, and also the shareholders to the company are only limited to the extent of the unpaid shares in that company. Then a company limited by guarantee, first of all, does not have a share capital, and the liabilities of the members is only limited to the extent of the the guarantee that they give the shareholders. Thank you.
Thanks a lot, Arunga. Thanks a lot, Arunga. I appreciate it. You've done very well. Now I'll give Alex to give his comments, then I'll give mine, then now we proceed.
Okay, in my opinion, I think you have done exceptionally well. You have not got all the answers right, but you have, at your level, you have really tried. The first question I asked you was the ways in which you acquire land, ways in which a person can acquire land. That is, I could call it the benchmark or the benchmark reel of conveyancing. What you study at KSL is conveyancing, ways of acquisition of land. So if you appear before a panel, you should really know the answer to that question, which in my opinion, you did not get right. When you look at Section 7 of the Land Act, it talks about ways of acquiring title to land. There is transfer, transmission, there is adverse possession. When you look at it, there's prescription, which is they call it adverse possession. You look at there are like 8 of them. The importance of that provision, as I said, it's a benchmark of conveyancing. If you go to that section and you look at maybe transfer is you got that right. Transfer is one of the ways of acquiring title to land. If you look at from how a transfer begins to how a transfer ends, and then you look at prescription, which is adverse possession, how does it start? How does it end? Then you go to transmission, where a person has died. How does it start? How does it end? When you look at those eight ways of acquisition of land, you are done with conveyancing. You have passed. You have got your P, your 1P. So the answer to that question was from that section, Section 7 of the Land Act. You can look at it. Now, on the second question, the Mitubel case, you got that very, very correct. That once you are in public land, the government should. It's Article 43 of the Constitution. You have a right to housing. The government should not just kick you out. On the issue of the other question, adverse possession, you are right, very right also. The reason actually I asked you that question is because after orals, there's a lecturer who asked that question in class. He asked, how are your orals? There's a question which I was asking people and they kept getting it wrong. When a person comes to Kenya School of Law and they stay there for many years, you have had your conversation, you appear the excerpt. How do you go about it? And there's this lady who lifted her hand and she said, I think she has a remedy, and the question really was, do you have adverse possession? Can you claim adverse possession of a government land? Kenya School of Law is a government land. And the answer is no, you cannot. You got that right. If the lady who answered that question in class was actually asked that question during orals and she got it wrong. And in the class, she responded, she thought she was right, but she was wrong. And I remember the reason I feel averse is I remember somebody just unmuted and said, "Oh my God." So yeah. So that's another. My fourth question was, if I remember, I don't remember what I asked you really. I asked you, what did I ask you? There's a question that I asked you, the fourth question. Michael?
Okay, just give me a minute. I'm also trying to remember the fourth question.
Competence.
Yeah.
Yeah.
Yeah. Competence, sorry. Competence is you got it, you are partially right. It's an arbitration term, which basically means it's the power of an arbitral tribunal to determine whether it has jurisdiction to determine the case that has been brought before it. So if you go before an arbitral tribunal and one party says, oh no, this tribunal does not have jurisdiction, and the other party who has brought the claim says that, oh no, the tribunal has jurisdiction. The tribunal has the power to determine, do I have jurisdiction? That is what is called competence. The answer you gave, your response was severability. Severability it's a clause, usually it's a standard clause in a contract. One of the boilerplates. Whose effect is that if one of the clauses in a contract is held to be void, that a holding by the court does not void the rest of the clauses. It's called the severability clause. I think you should also look at those. They ask them during orals. Severability clause, the waiver clause, jurisdiction clause, governing law. You should know generally those the surrounding questions. I think that was my last question, if I'm not wrong. I think you performed well, in my opinion. You have I think the thing with orals is you should have an idea. If you hear a term and you think it means something, instead of saying nothing, just say what you think it means it says. You might be right. I could have given you marks because of being close and not being right, as opposed to if you said pass. So I think well done. I'll give Solonga to give his remarks.
Thanks a lot. I also think Arunga, you did very well in that. So my question was, what's the difference between a public and private company? You got it very well. So the difference, maybe to expound on it, the difference between a public and private company is a private company restricts the right of members to transfer their shares. A private company also limits the number of members to 50. A private company also prohibits invitation of the public to subscribe to shares and debentures. And it's also not a company limited by guarantee. So that's a private company. So a public company is the direct opposite of a private company. A public company has no restriction on the transferring of shares. It doesn't limit the members to 50, and it doesn't prohibit invitations to the public to subscribe to shares and debentures. That's the difference between those two. And then the other thing that I asked was a difference between a company that is limited by shares and a company that is limited by guarantee. So for guarantee, companies that are limited by guarantee, the liability is limited to the amount members undertake in the articles, that is the guarantee to pay. But for shares, it's limited to the amount unpaid on the shares held by a member. So that's the difference between a company that is limited by shares and a company that is limited by guarantee. Other than that, you did exceptionally well, and you did great. So maybe one take from what we did with Arunga is, you remember when I asked you the difference between a public and private company, you mentioned the word shares. I hadn't even thought about asking you the difference between a company that is limited by shares or guarantee. But since you mentioned shares, it popped up in my mind. And that is what will happen in your oral exams. A lecturer will ask you a specific question, and then based on your answers, questions will keep on coming, yeah? Will keep on coming. So, for instance, I would have continued and be like, okay, companies that are limited by shares, what is the statutory documentation that has to be lodged? Statement of initial shareholding and all that, and statement of initial shareholding. And in the case of companies that are limited by guarantee, it's a statement of guarantee, something of the sort. So based on what you answer, that is how questions will keep on coming and flowing. Okay, thank you, Arunga. You'd pass very well.
Solonga, can I take it over?
Yes, Lavins, you can take it over.
Okay, Charity, are you ready? Charity. Orogi.
Can I be?
Can you hear me?
I can. I'm asking if I can.
Sorry?
Hi, Charity. I can't hear you very well.
It is
We can't hear you.
a question. I have a question.
Yes, please ask.
Is it okay to just say the private and public, or do you go to the specifics? When you mention this private and public, then you start saying a private company is this and this, and a public company is this and this, or you just go straight to the point and say private and public, and you're done?
Oh, yeah, that's a good question. Thank you, Charity, for that question. That's a good question. Thank you for that. I think I missed up on it. So if I was asked such a question, if I was asked in the panel, I will try and exhaust everything so as to try and close the questions from the panel. So I will search, what are the types of companies? They're listed very well in the Companies Act from Section 5 all the way to Section 10 of the Companies Act. So you will see there are limited companies, and a limited company can either be limited by shares or by guarantee. And to really impress them, mention the provisions of the law. Limited shares are found or governed under Section 6 of the Companies Act. Limited by guarantee is Section 7. Then you move on forward. They will also have unlimited companies. There's no limit on liability of its members, pursuant to Section 8. Then you can move on and talk about private companies and public companies, which are under Section 9 and 10, respectively.
Thank you. A second question, also on what you had asked Arunga. No, I don't think it was on what you had asked Arunga, but what Alex had asked. When you are talking about government land, is government land necessarily public land? I don't know whether it is a silly question. I've also asked it in the group, but is there any difference, or automatically a government land is public land?
Okay. To answer your question, if I got you right, a government land is public land. When you look at Article 60 or 60 to 63 of the Constitution, thereabout, the Constitution classifies land into three categories. There is public land, the land which people say at the shamba serikali. It's not government land; it's public land. So there is the Constitution creates public land, private land, and community land. Anything which is government is public land, and you cannot claim adverse possession of a public land. You cannot claim adverse possession of universities, public universities, of schools like the School of Law. You cannot claim adverse possession of a road reserve, because all those are public land, of national parks, such things. So you have to identify. Of course, they will not tell you Kenya School of Law is a public land or is a government land. They'll just tell you someone has come to the Kenya School of Law. So it's up to you to think, oh, Kenya School of Law, this is a public land. This cannot be community land. This cannot be private land. I hope I've answered your question.
Yes, you have. Thank you.
So Chaiti, sorry. Then we'll go to Gashiru. Gashiru, please go on.
No, I actually wanted to respond to that, but it has been responded properly.
Oh, thank you for that. So Charity, since you had lifted your hands up, maybe Lavins could ask you a few questions, and then you could attempt them. Don't shy away. This is what I did. I'll just tell you, when I began practicing for orals, before I did them, Anna would ask me several questions. I will not even answer. I would answer like half of them wrongly. I didn't even have an idea to some of them, but that's how my brain got tuned. Think of it as mental exercises. The more you train, the more you practice, the more you stand, the higher the chances of you passing, because you'll adapt to being asked random questions and questions that will enable you to think on your feet. So, Charity, Navins will ask you maybe a few questions, then I will proceed.
That's okay. That wasn't ready, but it's fine. Thank you for the encouragement.
No, don't worry. Now this is really good one.
No one is ever ready, Charity. You just have to brace yourself for the, for the storms. Yeah. So I'd start right away. So name 3 key players in criminal proceedings.
Thank you for the question. There's the prosecutor or the prosecution side. There's the defense, and then now there's the bench or the judges.
Okay. Are you aware of the Latin maxim nemo judex in sua causa? And if you are, where does it apply in terms of dispensing, justice to the adverse party? So where does the Latin, or the principle of nemo judex in sua causa apply?
I am aware of it, but it is not really coming to mind right now.
All right. You've heard of this phrase, frivolous, vexatious, and scandalous. So when do we say that a pleading is frivolous, vexatious, or scandalous? I just need 2 instances or 2 reasons why we say so.
Thank you for the question. I stand guided, but what I think is these words are used when maybe a pleading is out to bring someone else down with no good cause. And the second one would be, it is not any law, like in a pleading that is not brought under any law, there's no claim under the law, yet you are just coming to court.
All right. And my last question, when do courts strike out pleadings? Or why do courts strike out pleadings? Just 3 instances why a court will strike out a pleading.
Before I can get to why they would strike out a pleading, the Constitution of 2010 has clearly stated that courts cannot really strike out pleadings based on technicalities. So technicality cannot be one of them. So some of the reasons why a court would strike out pleadings is, 1, if it lacks jurisdiction, it will just strike out the pleading immediately. And 2, if it finds that there is no legal basis for the pleading being brought to court. Yes, those are the 3 that come to mind right now. The 2 rather.
All right, Counsel. Salonka, you may take up the mantle.
Thank you so much. Thank you so much, Charity. Lavins also. You've answered very well so far. You're good. Very well. Now, my question will be a hypothetical question that apparently somebody called me late at night to ask. Around 11 to ask me this question. So, Charity, as an advocate, you issue a professional undertaking to the purchaser that you will release the funds once the title has been registered in favor. Once the title has been registered in favor of the purchaser. In favor of the purchaser. A PU, a professional undertaking, has been issued by you. You are the financiers advocates that you will release the funds to the vendor once the title has been registered in the name of the purchaser. Now, the bank enters into receivership. The bank becomes insolvent. It can't pay off its debts. What recourse do you have as an advocate? Will the courts compel you now, to sum it up, will the courts compel you to pay that money, or do you have any other course of recourse as an advocate?
Thank you for the question. From the top of my mind, what I would think is, once you have signed a professional undertaking, it binds you no matter what. So even if the bank has gone under receivership, then you as the advocate who signed that professional undertaking, you are legally liable to ensure that the purchaser has received the funds that you clearly stated in your undertaking you will release to him.
I think that's very correct. That's very correct. Now, my last question will be, it's also a hypothetical case scenario question.
Okay.
You're an advocate. You're acting for Mr. Lavins. You're acting on behalf of Mr. Lavins. Mr. Lavins tells you that, let's win this case. Then after we win this case, whatever amount we get, I will share with you 50-50. Is there anything wrong with that particular arrangement as an advocate?
Yes, it is. That arrangement is wrong because as an advocate, how you file or how you are given the money is after filing a bill of costs, and your bill of costs should be in line with the advocate's remuneration order. So if it is not in line with that, then the 50-50 agreement is not right or legal.
Thank you very much, Charity. That will be the end of it for me. Now, maybe since I asked only 2 questions, I can begin then. Lavin will sum up. So you answered the first question very rightly. A professional undertaking is binding. Whatever happens, you have to honor a professional undertaking. It's an unequivocal declaration that an advocate gives to a party, telling them that you will do something, and it's binding upon the courts. And there's some case law. Actually, there's a case law I came across whereby I think the ruling came by last week but one, and the courts enforced that an undertaking against the advocates, despite the fact they were giving some reasons saying, oh, this and this and this, but the judge was saying, no, once you've already signed an undertaking, that thing is binding, and it's actually professional misconduct not to honor a professional undertaking. On the other aspect of whether the arrangement or that transaction between you and Lavince is proper, obviously the answer is no. You've given a very right and very valid position, which I had not even thought about it in the first place. You're supposed to be charging according to the remuneration order. I had not even thought about that answer. That's a very, very correct answer. And another scenario where it will not be a proper transaction is pursuant to the Advocates Act. Contingency agreements. I can't remember it's section 46, but you'll go confirm of the Advocates Act, which provides for invalid agreements. So contingency agreements, they are invalid agreements in the legal, and they are in the legal sphere. It's some form of it's even professional misconduct of a sort. Basically meaning, as an advocate, you do not represent a client so that you win that case. You're not there to win cases at all costs. Yeah. So such agreements whereby there are 2 things that are happening between the transaction between you and Lavince. You're having a share into his matter. That is not allowed. It's an invalid agreement. And the other aspect is you're having some contingency sort of relationships. That you will only be paid. You will only be paid if you win the case, which is not supposed to be the case. That's my side of the view. Otherwise, you did very great. As you will have passed greatly. I was a panelist. Lavince, you can take the next questions from Gasheru and Chege.
Okay. My first question to you, Charity, was about the principle of nemo judex in sua causa. So to the rest of you, HP students, class of 2021, 2022, I'd advise you at least to know, the landmark Latin phrases, because there are lecturers who will ask you, those Latin phrases because they assume you know, and you are supposed to know them. So the principle of nemo judex in sua causa loosely translates to you can't be a judge in your own case. So if you have an interest in any matter, you are supposed to recuse yourself as a judicial officer. So this particular Latin maxim is normally applied to judicial recusal. So if you have an interest in any matter, you're supposed to recuse yourself. But the party, seeking for your recusal will do so in 2 ways. They might do so through an oral application made in court to ask you as a judge to recuse yourself, or even a magistrate to just recuse yourself. And if you don't, recuse yourself, they may do so in chambers, still orally. So there's oral application in court, and then there's the oral application, but in chambers. So again, if you don't recuse yourself, they'll now do a formal application, you see, for judicial recusal. So this principle is normally applied, on judicial recusal. So just know that. On the other question that I asked you, it was about, frivolous, vexatious, and scandalous pleadings. So this is one way in which a court, may strike out pleadings. And it's the reason I asked you before I asked you, on why would a court strike out pleadings. So pleadings that are vexatious, scandalous, and frivolous are pleadings that are meant to waste the court's time. And Article 48 of the Access to Justice is so clear. Everyone has access to justice, and like you said, which was quite commendable, that if a court is supposed to strike out pleading, it should not do so on procedural technicalities. So substantive law, matters more, because procedural technicalities are things that can be fixed. So you can't assume that this matter, even without looking at the facts of this case, you just assume that because there was, mismatch, or there was an omission in one procedure, it could lead to the case being, or the pleadings being struck out. So the, substantive justice, is greater than procedural technicalities. So that's why the Constitution puts that caveat to barrier that the courts need to look at the substance of the case first. Yeah. So with all that, you did well, and I hope that you also scoop as many marks as you can in your orals, because you're capable, and I wish you well. So yeah, Salonka.
Okay, thank you for that. Thank you for that. Murugi, you did very well, Charity. You did very, very extremely well. Thank you. Now, sorry.
You had asked. He had also asked the parties of our criminal proceeding.
Oh, that's when you got it very rightly. You have the prosecution, you have the defense, you have the court, now the judge, or maybe the magistrate. There are other people you could learn, the police officers, there are who else?
Witnesses, the witnesses as well. Yeah, so
witnesses.
The accused. Yeah, that one you did well. You did well.
Thank you.
Awesome.
Yeah. Now, Gashiru has a question, then now we move on to Gitahi. And I see Noah has joined the meeting. Noah, you in?
Yes, Mr. Pareno, how are you?
I'm good. Thank you. Thank you for this. Maybe you will take Gitahi after he asks his question. Or
okay,
maybe...
traveling to Nakuru. So what I'm happy with is that I'm happy with the way the students are answering questions. And I'm having a guest, Kawakili, who also got a 9 piece. Nilikuja kumtembelea kidogo. So if you could allow me, the next person who is supposed to be interrogated, kama utakubali mimi na yeye, we ask the oral questions if it's okay with you.
Yeah, it's totally fine.
Yeah, he passed his by exam. So I thought it could be wise.
Yeah.
Because that's a little bit of time if he could, post some oral questions to the students.
No,
so
no problem. That's fine.
The two of us.
That's fine. Okay. So Gashiru ask a question, then now we proceed.
Okay. Thank you. My question is on this issue of the contingency fee. And I am alive to the fact that you see countries like in the US. In the US, it is not illegal for you to have the contingency fee, where they tell you that if you win a certain case, then you will get a certain amount of money. So is it then very wise for maybe the lecturers, if the lecturers specify and tell you in the Kenyan context, if you win a case, then or maybe you should give the two sides. It's like in certain countries, like in the US, if you win a case, you can enter that agreement of the contingency fee. If you win a case, then there's that amount of money that you're going to be awarded. Vis-a-vis the Kenyan context, where the same is illegal. Okay, that is my first question. My second question is on this issue of oral application when it comes to recusal. If for some reasons you find that you want to make the oral application in chambers, how do you make that application? Because I want to believe that even the other party could maybe object to the matter going maybe to the chambers. How do you ensure that you actually protect the sanctity of the court by not maybe embarrassing the court and asking for the matter to be mentioned in the chambers? Okay, those are my two questions.
Oh, thank you. Lavens will take the oral application one, then I'll take this one. Then Noah will go on. So on the contingency fee, yeah, this is the thing with ethics. It's theoretical. To be honest, it's really theoretical. Practically out there, people do this a lot. People do this a lot, contingency stuff and all that. But if you check section 46, I've opened it right now and confirmed the provision. It's saying nothing in this act shall give validity to any agreement by which an advocate agrees to accept in respect of professional business any fee or other it's the one that's above. Any agreement by which an advocate retained or employed to prosecute or defend any suit or other contentious proceeding stipulates for payment only in the event of success. Only in the event of success. Meaning, as an advocate, you're paid whether you fail or whether you lose or whether you win a case. So you should not have any sort of arrangement whereby you're only paid in the event you succeed in that particular case. So in the Kenyan jurisdiction, under Section 46, it's a completely invalid agreement. It cannot be enforced, and it will be unethical in that perspective. But in other jurisdictions, I'm not so much aware of it. If it's the case, the laws permit it.
So long,
Yeah, it's gone.
Yeah, you see, there's been an issue about the Advocates Act. Those of you who are in my lowest class, you will at some point talk about how that Advocates Act has been overtaken by events in many respects. And some people in the profession have been pushing for the acts to be amended to reflect the modern, to represent the current state of events. For example, and a good example is what you've referred to, the contingency fee, that you cannot agree with a client that if you win a case, you'll get some of the money from the proceeds, which you realize in Kenya the position as it is now is that you cannot hire an advocate if you don't have money. You have to be rich for you to afford a lawyer, because let's say, for example, these common running down matters, these accident claims. You see somebody has got an accident, they lost a leg or an arm, but then because they cannot afford a lawyer, because the law says that contingency fees do not apply, then you find that this person cannot get justice because of that particular provision. But if the law was that, yes, we can get to a contingency fee, and if you win this case, I'll pay the lawyer out of the proceeds of my win. It happens in practice, but in accordance with the law, as it is now, it's illegal. So that's just one example. There are other examples. For example, no one can invest in a law firm who is not a lawyer. You cannot get into an agreement with people who are non-lawyers for you to do a particular thing, for you to do a legal work. To do that in Kenya is illegal, which of course it does not happen in other countries. When you look at countries like US, law firms like Denton's, law firms like Clifford Chance in the UK, they allow people from outside investors to invest in the law firm, and then these investors can get some money, some profits from these law firms. But in Kenya, you have not got to that position. That's why people are pushing for, lawyers are pushing to amend this Advocates Act. So in Kenya, yes, it's illegal, but it's not in accordance with the modern trends which are happening outside there. Thanks.
Thank you for that, Alex. Now Gasheru, his land is up. So we had Gitahi. Gitahi, you could proceed. Then Noah can proceed with you.
Solonka, let me just respond to him on the oral application.
Oh, sorry, I had forgotten that question. Sorry. Yeah, please go on.
Gasheru, you know the common maxim that he who alleges must prove. So the law doesn't necessarily, make this process to be quite fishy, because the other party, now if assume you as Gasheru, you are the party, you're the counsel making the oral application in an open court. So two types of judicial recusal comes in form of oral application and formal application. So in formal application now, the opposing counsel has that chance to respond, because by then you'll file a notice of motion together with all other supporting documents. You understand? So it also gives that opposing counsel the chance, to also respond to your claims and why you would want this particular judicial officer to recuse themselves. And even in oral application in court, he is there with you. He may raise objections of the same, but at the end of the day, you as a counsel who is alleging that this particular judicial officer has some interests, which could be pecuniary, interest and other particular interests, you also offer the opposing counsel the chance to respond. And this also happens in chamber. So it's not as if the opposing counsel doesn't take part in all these things. At the end of the day, justice has to be served regardless of which side of the bar you're in, as an opposing counsel or as an advocate now for the person who seeks recusal of that particular judicial officer. So I think with that you're fine.
Yes, I am. Thank you.
Awesome.
Thank you, Alan.
Awesome. So long.
Yeah, that's fine. We'll take the rest. Don't worry. Gitai gone with Noah and Noah.
Yes. Good morning. Good evening, Mr. Solonka and Mr. Mutavi. I hope you can hear me.
Yes, we can. So you're asking Gitahi the questions, Gitahi Moses.
Gitahi Moses, eh?
Yes?
I have a question first before we may proceed, and even I'm not even in a position to answer because I'm on my way home. I've just stopped at a petrol station to maybe pick up from something that you mentioned earlier. So I may not be able to respond to the questions currently, but maybe the next time I'll be the first one, if you may allow me.
It's fine.
Okay. So I have a concern with previously on the question of PUs. You alluded to the fact that PUs are absolute in nature to the extent that they can't be, they can't be vitiated. That's what I got from your presentation, Solonka. So my question is, I understand that PUs are, exclusive from contracts of, sale of land and all that. But now my question would be, do frustrations and the vitiating factors apply to PUs? Because I'm looking at it from a point of catastrophe or a force majeure and all that, and I can't really get, but I understand that PUs are contracts in their very own nature. So I understand even the
Thank you for that, Gitahi. You brought it's a valid and interesting question. So let's start with PUs, with defining what a PU is. So a PU is just an unequivocal declaration to do something. An advocate, an unequivocal declaration of intention that an advocate gives another party that, I will do this and this if you do this. So in conveyancing, what happens is before funds are released, for instance, just one situation, there are various situations in which a PU will be used. So in conveyancing, you may have a situation where, and this is something that I was asked in my orals by Mrs. Kigwada. She asked me, there are times you have this kind of people who are the purchasers, but a very troublesome purchaser. And the purchaser will tell you, I don't want to release the funds until I have the land in my name. So what will you do as an advocate? As an advocate, you will write to the vendor that, I will release these funds to you. I will release these funds to you once the title documents have been registered in favor of the purchaser. So look at that transaction. What is happening there? You have a party. Now the vendor is that party. Is placing heavy reliance on your professional undertaking that, upon him giving you the title documents to go and register, you will release the funds to him. And this is why it's binding. The nature of professional undertakings being binding, it's like an absolute. It's absolutely binding. In such a situation, how would you allege maybe frustration and so forth. You know, this is it's an argument. It's some sort of argument or an unequivocal declaration. But at the same time, you have to remember, a PU doesn't even need to be in writing. An advocate can just go there and say, you know, I undertake to do this and this and this and this, and it will still be binding on that person. At that time, you'll see doesn't even comply with certain conditions for contracts and so forth under the Contract Act, you know, writing, consideration, and all those stuff. Once you give an undertaking as an advocate, it's not even taken as a normal. It's not taken as a normal argument and so forth. It's a solemn declaration as an advocate, a solemn, something that binds the profession. That, you know, I will do this. It's my word. I will do this once you've done this. I don't know if that's clear. Like it's how can I say it? Courts will seriously enforce it. And this is why they say, now, for instance, in those transactions, they will say, the courts will say, you know, you can't, you should not consider generally practice. You should never give a professional undertaking if you've not been placed in funds. You've not been placed in funds. And there was even a newspaper report before we did our exams last year. There was an advocate. He was acting for some parties. I think he was representing the financier. So he gave a PU that he will release 100 million. There is no way you could get out of that situation or that fix. You will have to, and you're obliged to honor that undertaking. And it's actually, you can check the topic. Let me see if I can Google it. It's straight up Standards of Professional Practice and Ethical Conduct. I don't know. It's topic. It's topic 9.
As you Google that,
yes.
So as you Google that, to add on what you said, on aspect of frustration, Moses, if the advocate who is giving an undertaking, you know, realizes later, you know, in time that there may be obstacles that will prevent that undertaking from being effected, then he has a duty to notify the other party or the other advocate to whom that undertaking was made that there are circumstances that will prevent the enforcement or realization of this particular professional undertaking. So there are those frustrating factors. You know, there's the force majeure, they're there. So a PU isn't a contract. And it, like Solonka said, it's not even supposed to be in writing. But you have that, it has that, you know, solemnity in it. So you are supposed at the end of it to enforce this particular undertaking. So if you feel like there will be, you know, unforeseeable circumstances that may prevent you or your client from fulfilling this undertaking, then you can just notify the other advocate so that we know this professional undertaking may not be effected because of this particular reason. So that's where frustration comes in. But at the end of the day, you can give them the period. Like after 2 months, the professional undertaking may be effected. So yeah, that's it.
Yeah, that's it. Now I've actually found the specific provision. So PEC 9, professional undertakings, and why it's a really binding and solemn thing. Like, other than it being enforced, you being told to pay the 100 million, somebody can move to the advocate's disciplinary tribunal and it can even be disbarred, or, you know, attract the consequences under Section 60 of the Advocates Act for not honoring a professional undertaking. So they're saying the advocate has a duty to honor any professional undertaking given in the course of his or her practice in a timely manner. The obligation to honor a professional undertaking remains until the undertaking is performed, released, or excused. So those are the 3 things: performed, released, or excused. You cannot go and claim any other matter like frustration, you know, force majeure, something of the sort. The only way an undertaking can be done, or you can get rid of it, is either you perform it, you release it, or you're excused from it. To fail to honor an undertaking is professional misconduct. So that would be the best answer. It's prima facie professional misconduct. You could look at various cases. Of all the cases I've read, the court will always enforce an undertaking. Always enforce an undertaking.
Yeah, so also please look at the case, the locus classicus, because lecturers also ask, you know, just try and master all these locus classicus cases. So the locus classicus for professional undertaking is Mugambi, Ayugi, and Jonjo advocates versus Jane Nyamboke. So look at that case. You'd be able to understand more about the PU. That's the locus classicus of the PU. Among us.
Could you come again, please? Sorry for interrupting. Mugambi Ayugi versus
Mugambi Ayugi and Jonjo Advocates. Yeah, Mugambi Ayugi and Jonjo Advocates versus Jane Nyamboke. I think, yeah, that's her second name. Jane Nyamboke, yeah. That's the locus classicus of PU. So read it amongst other cases to be able to understand PU more. And like Solonga said, the courts will always enforce a PU where there's failure by the party or the advocate to fulfill it. And it warrants a professional misconduct, which could be taken to the advocate's, disciplinary tribunal or advocate's disciplinary committee to have that advocate punished. And in punishment, you will be struck off from the role of advocates. A fine could be imposed, or you may also be, just among other disciplinary measures. Yeah, so that's it. So back to you, Solonga. I think we can now give Noah the chance, to
ask.
Take over.
Yeah. So Noah, you will take over. So thank you, Gitai. Alex has even pointed a very good case law. You will check it out. The advocates are told to pay 102 million. They were told to pay 102 million. So you could check it out in the WhatsApp group. So the next thing, who has his hand up?
Kindly, one question on PU.
Okay, no problem.
Yes, in a situation where an advocate acting for the purchaser decide to give a PU, and is the fund remitted to him, he gives a PU to the advocate for the vendor, indicating that kindly supply us with the completion document, and once you do that, we shall pay the balance of the purchase price. So, and then now the advocate acting for the purchaser, the bank which the money was deposited in goes under receivership. In such a scenario, is that advocate entitled to enforce or to fulfill his the terms of the PU? Thank you.
That's a very interesting question. Or the account in which he placed those funds, the bank has now gone under receivership.
Yes.
If I can get that's the question you're asking, huh?
Yes, it's a question.
Hey, that's an interesting case. That's an interesting because that one. Now maybe I'll do more research on that, but I can give you some perspective I have. And this matter is a matter that is ongoing in court in the firm that I work with. So you remember Chase Bank entered into receivership, yeah? Chase Bank entered into receivership. So what happened is a few months before Chase Bank went into receivership, some clients, now the clients we're representing, it's an international bank, it's an international banking institution from France, had given over $1 billion Kenya shillings to Chase Bank. Then all of a sudden, Chase Bank went into liquidation. You know what that means? What that means is if a company or an institution goes into receivership, what will happen is the order of paying debts is the company there will be a receiver who will be appointed. He will liquidate the company's assets, and then debts will start being paid from order of priority. So you start with secured creditors, and then you go on to unsecured creditors, and so forth till everyone is paid. So our clients were, and it's going in court. The matter has not been determined. I think it's the first of its kind case in the country. The matter has not yet been determined. So what we are arguing in our pleadings is that this money that we advanced to Chase Bank was not. It's not their money. It's basically held as a constructive trust. Meaning, if something is held on a constructive trust, if it's paid for a specific purpose, the money is being held in trust, and it reverts back if it's not being utilized for that specific purpose. So we are alleging that we're trying to prove in court that this money should not be distributed according to the order of. It should not be distributed according to the order of priority because it's not the bank's money in the first instance. It's our money. We created some form of result or some form of constructive trust or a quist closed trust and so forth. So that's the kind of an argument trying to put. But this scenario of yours is raising very interesting points that has to be looked into. So this is an advocate. He placed the money into the bank account. And to be honest, I'd have to do more research on that. It's raising a valid question. It's raising a valid question. It's a valid question. I'll have to look into that and then get back to you.
Lonka.
Yeah.
It's Gitahi again. Sorry for interrupting, but I think it's now well put by Andrew or whoever asked. I was avoiding to ask the question, but that was my question. Yeah. I just tried to, hide some, we have a common interest in that area. Everyone is here who's benefiting from this forum, but that was my question. So there's money put in an advocate's account, and it's beyond their measure that money. See, so the PU has been frustrated. That was my question.
PU has been frustrated. So it's no fault of either. That's a very interesting question. Also, I'll do more research on that. I'll get case laws, I'll consult with some of my colleagues, and then maybe in the course of the week or maybe the next meeting, I'll try and hit you up. But that's a very interesting question because it raises a new issue altogether. So we can have now Wanyama Vero, and since Noah was supposed to ask questions, he'll take a few minutes. You could ask your question, and then Noah will take you through some few questions, kindly. I remember you Vero used to study together in campus. Noah, please go on with Veronica.
Wait, I'm having a question. Hi Solonka, hi Lavins, nice to catch up again. I have a question regarding answering orals. For example, if you are asked, what is professional undertaking? You do not have the specific terms to describe what professional undertaking is, but you know a scenario where it can describe the professional undertaking. Are you allowed to use this scenario? Are you allowed to use this scenario and use it to explain the professional undertaking?
Yes, you're allowed to use it. So the thing is about orals is you need to at least show the lecturer that you have an understanding. You don't need to get all the answers correctly. You don't need to get it pitch perfect correctly. You don't need to be 100% accurate and correct. And this is something that happened to me. I didn't answer everything perfectly, but I had an idea in everything. And it's better if you can even pair it together. You could give a hypothetical scenario of sorts. Remember when we were engaging with Gasheru initially when we were doing the meeting, or when we started, how I explained interplead and how I explained Ganishi. I didn't even use technical legal terms, but I explained them very well what they mean. So yes, you're allowed. And Vero Toroki, you're not going to hear further questions. Noah, please ask Veronica a few questions.
Seriously, Solonka, sawa.
Yeah, please, Noah, go on.
Yes, Veronica.
Mr. Solonka, before Mr. Noah can ask a question,
yeah,
I wanted to attempt the issue of professional undertaking in terms of the question that have been asked by Mr. Gitahi. The same question was actually raised in our class, and the lecturer actually didn't give us an exact answer. He just told us that a professional undertaking is a form of extending a warm hand or just being courteous to the other advocate. So like the only thing when found in that situation, he told us that the only thing you can do is you make sure you have informed the other advocate as earlier as you can. And it just depends on what the other advocate will do. If he's an understanding person, maybe he will let you go on that professional undertaking, or if not, then the proceeding, maybe the disciplinary proceeding will take over or will be taken to court for that professional undertaking. But he just told us when a situation arises in terms of professional undertaking, you are either between a hard rock or a hard surface. That's what he told us regarding that. So as you continue doing your research, maybe you can come with a conclusive answer next time in meeting. Just consider that submission I've made.
Thank you so much. Thank you so much. I'll actually I'll look into that, and I'll also get more case flows on it, because that's how I remember when I was reading SOPEC 9. It can either you perform it, either you release it, or either you're excused. You don't even give any other alternative. But I'll do more research on it, and then I'll come back to it. So back to Noah and Wanyama.
So good evening once more. Who am I asking the questions, Mr. Solonka?
Veronica Wanyama.
So Veronica, kindly unmute your mic. So I'm Noah Oreda. I was a classmate of Solonka, class C. So with me, I have a friend who also passed his bar exams. He was in class A. So he will introduce himself to you before I ask the questions. So Mr. Kamau.
Hello everyone. My name is Kamau. Ole Madingira. So long as I don't know, I'm also a Maasai. I'm a Kikuyu on the other end. From class A. I'm asking very important. Thank you.
So Mr. Kamau was apparently my roommate in campus from second year to fourth year, and then he was my neighbor also in during KSL. So we passed the bar exams together. I think it was also a blessing on my part, and also his part that at least we are somewhere with him. So Miss Veronica, I'll have only 4 questions for you. So these my 4 questions will only touch on 4 units. So my first question is, what do you understand? What is the difference between the doctrine of lapse and the doctrine of survivorship? What is the distinction between the two? Kindly.
Sorry, the doctrine of what?
The doctrine of lapse, and distinguish between the doctrine of lapse. This is a probate question. Distinguish between the doctrine of lapse and the doctrine of survivorship.
Good evening, sir. Thank you so much for your question. The doctrine of survivorship goes insofar as saying a couple living together, or rather partners in a marriage, who will be able to survive the other in order to succeed the property that will remain. So the doctrine of survivorship basically says the person who survives later will be able to succeed the property. And I think it's also worth noting that partners in a marriage do not actually acquire property, but they acquire lifetime benefits. The doctrine of lapse, on the other hand, I'll stand guided on this, but I think it is a doctrine. It's a doctrine where it's a doctrine where once you agree on a specific period of time, and once the period or rather the contract lapses, then you decide who survives, who takes over the property. As
the microphone. So this is an application question. So suppose you are Miss Veronica. Suppose your client, let's call the client Kamau, is arrested on a Thursday, 11:50 p.m. That's at, around night. Then on a Thursday, then you are not able to see him on Friday, but he is presented on Monday in court. What pleading or application will you file in court?
The first thing that is worth noting in this particular case is the period of time by which an arrested person is supposed to be produced in court, and an arrested person is supposed to be produced in court within 24 hours, unless it's a Friday or a day preceding a national holiday. Then that time stops counting until the next working day in court. So once this person is produced in court and the time has lapsed, the 24 hours has lapsed without reasonable explanation from the police, then as an advocate, you're supposed to go ahead and tell the courts that my client was not produced in time. And I think, or I suppose, such a pleading would be a chamber summons, probably. So so that it can be heard ex parte.
Veronica, I've lost you. Have you finished?
Yeah, I think she finished answering. She's waiting for you to go on.
Okay, so the third question is, what do you understand by the term moratorium? It's a commercial transaction question. The term moratorium.
Oratoria. Okay. This is a
Moratorium.
Oratorium or moratorium?
Moratorium. It's the singular for moratoria. So just answer the moratorium.
Okay, we are not yet there, but I think a moratorium is when a company or when directors are prohibited from doing a certain activity, even though is in their memorandum of association or article of associations, is inter-various to the activities, but they're rather temporarily prohibited from carrying on such an activity. It so far applies also to deaths. And yeah.
Fair enough. So the last question before Mr. Kamau asks, I'll ask you a certain question I was asked in oral, but I'll give you certain points so that you may be able to answer certain, subtopics. So during my introduction class, I talked about the question I was asked in oral, the Syokimau case. So what happened, so that I can help in the Syokimau case, what happened is that if you watch the Citizen News, about last year, what happened is that there was a particular company who was, which was emitting certain gases. There was some emission of gases which affected certain people, their lives. So my question is, with regards to that scenario, basically, those who have been affected have approached you as an advocate, Ms. Veronica. So I'd like you to tackle on three things, so that we cut short my questions. So my issue was, the first question is, my first three question is, so that you can just briefly, because of time, the issue of what pleading, let's assume the demand letters have been filed. So the question is, what pleading will you file? Number two, the jurisdiction. And then just to guide you, number three, issue of representatives. Just touch briefly on the issue of that question. I hope you have understood my question.
I have understood, sir. Thank you for the question. The first thing is that this is a representative suit matter. It means that the plaintiffs are too many to be able to be listed, all of them in the suits, all of them to be listed. So one person takes up the opportunity and asks for authorization from all these plaintiffs, asks for authorization to be made a representative. The other parties will be the unnamed parties of the representative suit. Even though this suit is a representative suit, notices must be served to all the parties. Further, also, in the case of a representative, suit, a party may decide, one of the parties may decide not to be included in the representative suit. And in such a situation, the judgment given in the representative suit shall not bind this party. But once a party does not give notice to be excluded from the representative suit, then the party is bound by whatever outcome will happen in that specific case. A representative suit is usually instituted by way of plaints, and and it's in order. It's in order 1, Rule 8 of the Civil Procedure Rules. I hope I've answered all the questions, sir.
So thank you very much. So I'll pass you to Mr. George Kamau so that he can be able to ask you questions. Mr. Kamau.
Hello.
Yes, sir.
Thank you so much. And perhaps to give you some morale, I also failed my oral exams. I got 10, so do not be scared. You pass the exam. So I have 3 questions, and I'm hoping that you'll be so precise and straight to the point. Can you just give me your understanding of the doctrine of constitutional avoidance? What do you understand by the constitutional avoidance?
Consumer avoidance.
Constitutional avoidance. The doctrine of constitutional avoidance, yes.
Oh my God. Okay, I will attempt, but I really do stand guided.
You also have a leeway to say pass so that I can ask you the next question.
No, I'm not going to say pass. I'm going to try. I think constitutional avoidance, the literal meaning of the word constitution is what has been provided for in the constitution. Avoidance, the literal meaning is generally to escape. So I will refer the doctrine of constitutional avoidance as those issues in the constitution that the constitution does not specifically tackle. It attempts to leave it to other states to tackle, and the constitution does not directly tackle or give a solution to it at the time. I hope. Thank you.
Okay, very well. Thank you so much. The next question is, can you give me names of 7 judges of the Court of Appeal?
The Court of Appeal is first constituted of of 7 judges. The quorum of judges in the Court of Appeal is 5, meaning only 5 judges are needed in the Court of Appeal in order to pass any to pass a judgment. That is the quorum. So the 7 judges are my namesake. I hope she's still there, Lady Justice Nambuye, as the president. I'm thinking as the president of the Court of Appeal. The next, sorry.
No, continue.
Okay. The next judge will be Mr. Singer, Lady Justice Karanja. Oh my God. I am not sure if I'm saying the correct thing, but I will stop there so that I don't misguide the others.
Okay, well, my last question is the types of the question that I'm asking you are the same kind of the question that I was asked in my own exams. So do not be scared. So I'm hoping the others are taking notes. So my last question is whether a person or an advocate or a lawyer is supposed to ask leading question during re-examination. I still think that you're not there yet, but I can still pose that question, whether you can ask leading question during re-examination.
All right. There are 3 types of examination of a witness. There is examination in chief, there is cross-examination, and re-examination. Re-examination generally comes in to dispose the facts that have been, to put an exclamation on the facts raised on the cross-examination. So yeah, the counsel is allowed to ask leading questions, but the leading questions should only point to the questions that have been asked in the cross-examination.
Okay. So when are we making the rejoinder so that I can
Well, you guys asked I won't add any other question. You guys asked it exhaustively. Maybe my comments, then you could answer her. Vero, you did very well, extremely well. You didn't skip any question. You didn't pass any question. That is a very good thing. Yeah. So for me, you did well. You did well. Now maybe they can air out on some areas where maybe you weren't 100% okay. But then law, you don't. We say you're always okay. I see. There's no wrong answer in law. Okay. This is what I usually say. There's no wrong answer in law. You just argue differently. So maybe they could clarify on some of the issues they asked. Oh yeah, and before I go on, yeah, orals are that unpredictable. In fact, recently with the BBI judgment, you can go there and you find somebody like Omosa and he'll be like, mention 7 Court of Appeal judges. That's something that I assure you at least one person could be asked. Or maybe mention who's the president of the Court of Appeal. Then they go on. Who's mention the Supreme Court judges? These are questions that are really asked during the exam, during the oral examination. It's really an unpredictable experience, but don't despair. Don't give up hope. You'll pass, and even if you don't pass, there are still marks for the main exams. There are guys who didn't do very well, but they still passed in the end. So you'll hack it completely. I'm sure. No, gone.
So, Mr. Solonka, thank you very much. So I'll allow Mr. George Kamau to make his comments, then I conclude, then we wait for the others who are willing to take the question. So, Mr. Kamau, take over.
Thank you so much. In regards to what Madam Veronica has answered my questions, it's very well, and perhaps for me, I can give her a 14 out of 20. My experience with orals are not a good one because, as Pereno has said, you cannot predict or you cannot revise or you cannot read for oral exams. Questions can come all over the world, and you can also be asked the simplest questions of all. Like, for example, my friend was asked, "Why are you wearing a mask?" You see, and he was given his 18 marks and all that. I was also asked for 30 minutes, I was asked lots of questions in civil litigation, trial advocacy. So, and you can see, and I was the first one in my panel to get 10 out of 20. So you can imagine what others got. So I did poorly in my oral exams. Equally, I did poorly in my project, but I still passed the exams. So do not take it so seriously. It's not a matter of life and death. So, Madam Veronica, when you ask a question, it's good that you gather marks. You try to say what you know about the topic, and you did well. And also, like for the first question, the question of judges of the Court of Appeal, just name judges that you know in the world. Just say Pareno. Just say no. You don't keep quiet. Just say the name that you know. You might find that Musinga is also called Pareno in the surname. You don't know, so you just name the name that's in your head, because there's no time of thinking in oral exams. Okay, the doctrine of constitutional avoidance, we talk about constitutional petition. Any claim or any issue or any matter in this republic or you can encounter raises a constitutional avoidance. There's an advocate called Dr. Kamau Kuria. Dr. Kamau Kuria will find a constitutional issue in a road accident issue. So the doctrine itself says that can you find remedy outside the constitutional petition? So it does not necessarily mean that you go to a constitutional court to interpret whether you are aggrieved or not. You can also go to the civil court. You can raise your claims there, group claim. So the doctrine of constitutional avoidance is there to avoid people piling up the constitutional petition, because any claim can raise a constitutional issue. So that's the point of departure. Go and read petition E353 of 2020. It raises the issue of constitutional avoidance. The last question was on re-examination. Please, try as much as possible to think as an advocate. Leading question can always be asked with the leave of the court. With the leave of the court. Mr. Mwaneki will like you very much if you say the leave of the court. And I think when I said leave of the court, that's the point that gave me the 10 marks in my orals. Otherwise, I would have failed. Thank you so much, Madam Veronica, and I wish you well.
Yes, thank you very much, Mr. Kamau. So I can attest as well, Mr. Kamau, we went to the oral exams on 4th of December, am I lying? The same day. So I went out of the exam room a bit happy. He was mad at, when he was out of the exam room because how he was treated in the exam, the oral exams. But eventually, what I'm happy is that he passed his by exams. I think today I came to celebrate with him, him passing his by exams. So what he has said is true. Miss Veronica, it's good. Me, I'm encouraged and I'm happy, and I've learned a lot. We were taking notes when you were talking. Before we started asking questions, when I arrived at his house, I told him that I was supposed to attend a meeting at around 8, and he told me, my brother, the pens are ready. Just log in and we learn, because at this time most of us have forgotten what we learned in class. So I've learned a lot from you personally. I was taking notes. However, me personally, I'll give you the same marks as Kamau has given you. So I'll just take you through the 4 questions, just give you basically the answers. Me, I'm happy because you did not pass. You followed Mayar's advice if you attended the first lecture. So the issue of lapse and survivorship, you answered the part of survivorship correctly. You know, the issue of survivorship, basically the difference is in survivorship, the beneficiary, the owner of the property or the proprietor dies before the beneficiary. So the beneficiary survives. So he or she will inherit that property. But the doctrine of lapse comes where the donee or the beneficiary dies before the donor or the owner of the property dies. So the doctrine of lapse will come in at that particular point. The gift will lapse, and therefore we'll, instead of going to testacy, now we'll go to intestacy. So that's where the difference lies. Now, when we come to the issue of moratorium, moratorium is under administration. Administration is an alternative to corporate insolvency. So I'll urge you to go and read about administration. So just to ease or jog your memory, moratorium comes in where, and I'd like you to read the Nakumat case and I think the Taskis case, where you make an application to court so that maybe you rented a place and they wanna quitisha rent in that particular property. So you make an application to court so that you stay those rent arrears, you seek for those orders so that those particular people who are claiming against you, they are being barred from making those claims. For instance, if let's take an example of Taskis. You may find that they have arrears, they have so many stores, so they have arrears. So what happens is that they run to court, tell them, we need to seek a moratorium order, and tell them, we are entering into an administration as an alternative for liquidation. So we need to seek an order to stay so that those people don't seek the rent arrears they need. So we stay them such that they give us time so that we can pay them. So the moratorium is always, they're always valid for like 12 months. So after 12 months in a lapse, so the landlord can seek, they can move to court so that you can able to, seek for those rent arrears that those particular persons to pay. Then number 3, so that I can go quickly, issues to do with Stokimau. I gave a case, so I cannot go back to it again. So I asked about the pleading, the jurisdictional representative suit. You tackled on the representative suit. So what happens is that I've given you a scenario. The demand letter has been filed. Hizo takataka zote. So what happens is that all those people who have been aggrieved can agree that 2 people, maybe 2 or 1, can, represent them. So what happens is that they go to the ground, write a list. It is practicable. You go to the ground, write a list of, maybe there are 50 who have been aggrieved. They must sign all, the document consenting to you representing them as per Article 22 of the Constitution of Kenya. So the consent letter must be signed. So that letter will give you, that authority that you will be able to represent the other 22. And number two, when a judgment has been given, then it will bind all those people who have signed that particular consent letter. Come with a sign, then even if the court gives an order that favors, maybe particular monies are issued, then you are affected, but you do not sign that particular letter, then you are not binded by that. So you cannot claim. So number two, jurisdiction. What is the jurisdiction? Jurisdiction is the ELC. Remember, the issues to do with the environment. Number two, land. Gases, nini. So what you do, you file a petition. Just to answer the issue of pleadings, you do a petition either in the High Court or the Court of Equal Status. And most rulings have stated that, so because the High Court has been overwhelmed in a lot of petitions, you do a petition with a court of equal status as the High Court. So what you do, you file a petition with the Court of Equal Status of the High Court, which is the ELC court. So just to answer Ms. Veronica's issues to come out. So the pleading is the petition. Do a petition to the ELC court and a representative suit. So you can choose who to file the suit, and you must all sign. That's how I answered my question there. Then issues to do with the person who has been arrested. I liked how she deciphered the question, 24 hours. But remember, this person has been arrested in 11 usiku, satano. So remember, 24 hours is around 11 usiku. So that means it will be pushed to 11 to Monday, because 11 on Friday courts do not operate, so it will be pushed to Monday. So what you do, you file for the first application that you must file is what we call an application for bail, and this is via, you can do it mostly kwa ground orally, but for exam purposes you do an application via notice of motion. So that's all I can comment. Ms. Veronica, you did well. I'm happy. Mr. Kamau want to add something.
So if may be allowed to make a rejoinder on the issue of moratorium, and also to give people hope. I got 10 in my oral exams, and also equally I got 8 in the project. We were taught by a very serious teacher called Mr. Ndolo. And if you are taught by Mr. Ndolo, you must be very careful of what you are doing in Kenya School of Law, because you are going to fail in your projects, however good your projects are. So moratorium. So I think I got 50 out of 60 in my by exams in the CLE exam. So moratorium is simply, for example, if you are a debtor, some people, you enter into an agreement with the people who gives your creditors so that they can postpone your payment of your debts. So it's simply that agreement that you enter into to postpone the payment. So never forget about that, Madam Veronica. Is just moratorium is just a postponement of payment of your debts. Never forget any kind of moratorium. If you hear banks, debtors enter into a moratorium, it's an agreement between you and your creditors to postpone your payment of your debt to a future date, and it's always agreeable in that set of moratorium. So never forget about that, and you'll be asked in orals and also in the exam. So Mr. Poreno, I request to retire, and I thank you so much.
It's fine. Well, thank you so much for coming in. Thank you so much. We could join you, and then you'll be part of this more often. So thank you so much, and encouraging words.
I can help in drafting and commercial.
That is very fine.
I'm gifted in that, and also I'm looking forward to. I was also trained by several advocates from Triple K, and also feel like I'm indebted to give back to the society. In fact, I was the person who invited Mr. Noah to that discussion, and it was fruitful. So I don't, and the students are doing well. I pray to God that they are going to pass, and I pray that they do well.
That is very nice. I really appreciate it. I really appreciate it. So yeah, as you see, we'll do drafting exercises also. So don't worry, we will do drafting exercises with you. Before you do the exams, we'll have guided you completely very well. So Gasheru, you had your hand up, and then Ngatia Sharon.
Thank you very much. Let me start by saying that I am very, very impressed by Mr. Noah and Mr. Kamau. I think friendship is very, very important. And I think the fabric of every profession is for you to have friends that you can always identify, you can always talk to. And I am glad that one time, I'm going to say that Mr. Solonka and all the other members really helped me to pass my bar exam. So thank you very much, Mr. Noah and Mr. Kamau, even for those questions that you asked my colleague, Ms. Wanyama. So my concern is on the issue of constitutional avoidance. And then I think you did state that you may choose whether to do a petition or maybe to do a civil claim. I just need some clarification on that. So is that the position? Let's say that you have been denied possession, let's say a property under Article 40 of the Constitution of Kenya, where you feel that you may choose to do a petition, or you can just choose to do a normal suit to the ELC court. So is that to the position of constitutional avoidance?
Thank you. So, for example, a client comes in your office and tells you that he was working in Safaricom and he was dismissed from employment. He was not paid annual leave. He was not paid severance pay. He was not subjected to fair labor practices as entrenched in the Constitution. So, in that scenario, you can do a constitutional petition to say that your client was denied his constitutional rights. However, in that same question, you can also file a memorandum of claim in the Employment and Labor Relations Court. So what the doctrine of constitutional avoidance says is that, and I gave a case, petition E343 of 2020, is that as much as every dispute raises a constitutional issue, it is not as of right that you are going to file a petition. Other courts provide, there's other avenues that you can pursue your remedies from. And those is profound in courts that are set in our country. We also have, Noah spoke about court, the same jurisdiction of the High Court, because you see, the High Court has unlimited jurisdiction to do that, which is interpreting the Constitution. So you can opt to go to an ERLC court for an employment issue, where your client can be remedied, other than going to the High Court to seek that your client's constitutional rights has been infringed. So it is a question of when an issue has been brought to you as an advocate, are you going to avoid the issue of constitutional avoidance and go to other courts where you can find remedy from? So it's a matter that has been litigated every day in our courts. Recently, where I'm working, we filed a petition which also raises employment issues. Then the respondent counsel was saying that, no, I'm going to raise a PO because the advocate of the claimant is supposed to do a memorandum of claim rather than a petition. So it's a doctrine that says that you should resolve your dispute outside a constitutional petition. And when you are asked in oral question, you just say simply that it's a document that interrogates whether there are ways of resolving dispute outside a constitutional petition. So you should always stick to that few words that I'm saying, that it's a doctrine that interrogates whether a person can seek a resolution of dispute outside the constitutional petition. I hope I have tried to answer your question, and you can make a rejoinder.
Yeah. From what maybe I've gotten from your explanation.
Pardon?
Maybe from what I've gotten from your explanation is that you should avoid as much as you can to do a petition.
Yes.
But then you go for other options.
Yes, but when you should give an interpretation, an explanation that these are doctrine that seeks to interrogate whether a person, when a person is confronted with an issue, a legal issue, when that person tries to resolve that dispute, is it possible to resolve that dispute outside a constitutional petition? Because there are remedies one can seek from a constitutional petition: conservatory orders, declaratory orders. You see, if you go to a constitutional court, issues of damages, words, you cannot be given. Like, for example, where you say that you want to be given severance pay, or you want to say that you are seeking annual leave pay, you are not going to be given. That is not the work of the Constitutional Court. The work of the Constitutional Court is to ascertain whether your rights as entrenched in the Constitution are violated. And all claims, whether be it accident claims, whether be it custody claims, whether be it family matters, they all raise constitutional issues. And Noah and Mr. Pareno can attest to this, that any dispute raises to a greater extent a constitutional issue. So the doctrine says you do not have, you are going to read, you are going to be taught in civil litigation. I think that's a topic that you are going next to. That the doctrine tells you that you can always interrogate whether you can solve your dispute outside the issue of the constitutional violation and all that. I hope Mr. Pareno and Noah, I have answered that question.
Yeah, spot on. Like every dispute has a constitutional connotation to it. But the doctrine of constitutional avoidance just says, if you can resolve it outside a constitutional court, then do so. So don't bring every issue and guise it under a constitutional petition. Justice Kiagi of the Court of Appeal terms it the art and craft of drafting pleadings. You cannot just draft your pleadings to include one particular provision of the Constitution and then go to court looking for constitutional remedies and all that. If you can adjudicate your claim outside a constitutional petition, then do so. Hey, time is going.
Sorry, Brian, but
yes?
I need a clarification. There's a case actually mentioned by Mr. Kamau. I didn't get the petition number. Maybe a request for clarification on that.
Okay, Mr. Kamau, please give the case.
Yeah, when you go to EKRL, I hope Mr. No and Mr. Pareno, you have taught the lawyers to go to the Kenya Law Reports case database and how we search these cases. So you just write the petition E343 of 2020. It has expounded on that on that issue. Have you gotten the case?
Yes.
Hello?
Yes, you said if the
thank you.
Yeah, it's E343 of 2020. It raises issues of constitutional avoidance. E43, huh?
Sawa, asante.
Since Ngache is not here, maybe Ogola, Esperance, and then if she joins, then Ngache will go on, proceed. Ogola, you could go on, please ask.
Okay, good evening. I hope you can hear me.
Yes,
Hello?
I can hear you. I can hear you very well. Yes, I can hear you.
Okay. Just on that note on constitutional avoidance, I'll ask to seek your guidance. It's a project work we have, and we seem to be confused on what way to go. It's a criminal litigation project work, where we have an application for habeas corpus. So such an application can be approached in two ways as far as my knowledge is concerned. You can either approach the court through a petition or through a chamber assembly. So in the light of Article 51(2) of the Constitution and the doctrine of Article 51, which says that you should approach such an application through a petition, and the issue of constitutional avoidance, where you can go for an alternative, which is a chamber summon. So in an instance where you have such a conflict, what happens? What trajectory do you take?
Thank you for the question. No, I can go on.
I can attempt, though I'm subject to correction, though Mr. Kamau can also attempt. There's been an issue of, and I think we discussed this with Mr. Solonka, issues to do with what the school teaches and what the ground, what is in the ground. So what the school teaches is that, when it comes to habeas corpus, it is the, chamber summons. And Mr. Ogola, I know I might not answer this question fully, but if you look at just look at the question, because when it comes to criminal, it mostly confuses people. So me, from my understanding, as from where I am, you can do two options. I think from my experience, when it comes to habeas corpus, because I saw one petition in 2016 via EKLR, I saw Mr. Nelson Harvey do a petition. But when I looked at the judicial bench book, when it comes to habeas corpus, you do what we call a chamber summons. So I'm of the understanding that there is a certain ruling that I think by Justice Lesit, I stand guided Mr. Solonka that issues to do with chamber summons. So there's a bit of confusion on what to do. Do we follow the syllabus, what the syllabus states, or what, Wagrao Vilenaka? Because I have also looked at that particular question because I saw in our engagement, I looked at what Justice Kiage said in his book in Essential, in, I think, Criminal Procedure, and vis-a-vis I compared it with what the judicial bench book and what the syllabus, says. When it comes to issues to do with habeas corpus, we do a chamber summon. However, Justice Lesit, I don't know, Mr. Solonka, you can also intercede, and Mr. Kamau, they intend to, eradicate what we call chamber summons to replace it with petition. So there's that a bit of disconnect, but I'll encourage you, just do what the teacher said. If it's chamber summons or what the course outline says, do the chamber summons. Me, I encourage you personally, because what I study in the campus when it comes to habeas corpus, you do a chamber summons. So I'll let Mr. Kamau try to answer the question. From my understanding, I may not have answered the question correctly, but I'll just give you my thought of it. Different judges and what they say differ. But the course outline I know says you do a chamber summons. I was also taught by Mr. Moss. He told us that it's a chamber summon. So there's that argument in in the legal profession. So I'll let Mr. Kamau answer, and then maybe Solonka can also give his idea on that particular question. So Mr. Kamau.
Thank you so much, Mr. Noah and Mr. Arno. The question, the Wakili who has asked that question is a brilliant one. Article 51(2) gives a right for one to petition for habeas corpus. The Constitution is a ground norm, so you can do a petition where you want to do an habeas corpus. But remember, criminal issues is where you want. They are done. Those are issues that are done in urgency. So what are you supposed to do first? Mr. Omosa will tell you, do what you're supposed to do first. An application and a certificate of urgency will be heard faster than a petition. So, KSL is where we separate between the wheat and the chaff. The chaff will go for a petition, constitutional petition, where it will be heard. For example, you want this matter to be heard tomorrow. A constitutional petition will be heard next year after the general election. But when you do an application through chamber summons, and Mr. Noah and Pareno will concur, is that when you do a certificate, it will be heard tomorrow before noon or today before noon. So if you are a diligent student of criminal litigation, you will know these are serious issues that need to be heard on priority basis. You can imagine Noah and Pareno will tell you what amount of time it take for the court to hear a petition. Just imagine your client has been detained and you want that client to be produced in court. You see, you cannot go to do a habeas corpus, although it is entrenched under Article 51(2) of the Constitution. Is you do an application where your client will be brought to court and you dispose of those issues. So for me, if I was confronted with that issue, as a diligent lawyer, I would do an application through chamber summons and a certificate of urgency. Other people will do a petition. People will still get marks, but that's where chaff and wheat are separated. There are people who get 18, like the likes of Noah and Pareno. There are people who get 10, the likes of Kamau and others who did do petitions, and they are still right. So it's, KSL is where people is a concentration of intellectuals, where people will come with different ideas and they are correct. So I hope Noah and Mr. Pareno will agree that as that issue, which is an urgent issue, like where Miguna was detained, you will not do a petition because you know our courts and the delays that befallen our courts. You go by an application by chamber summons, and I hope we have those petitions. I hope Mr. Noah and Mr. Pareno has supplied you with those applications. You do an application and a certificate. The certificate will give you 5 marks. The application will give you the 5 marks. The supporting affidavit will give you the 5 marks. And I think the project is around 20 marks. 20. So you scoop your marks there. The petition, for me, I cannot. You can also do a petition and a certificate, but just go with what you are taught by the teacher. Mr. Mosa tells you, just avoid issues of the Constitution. This is a criminal litigation class. Constitutional class, you go to study it in civil litigation. So thank you so much, Wakil, for that question. But as a brilliant student of constitutional law, bear in mind that you also have a leeway to do a petition for habeas corpus. As a criminal litigation lawyer, just know that you can do an application and the certificate of urgency and chamber summons. You can also do via notice of motion. I've done several, and no one has died in this court. When you come out from KSL, lawyers will tell you, this is not academics, this is practice. So thank you so much for that question. And I can advise those students who are doing that project. I have also advised students from Kabarak University, where I'm an alumni, to go by the certificate, do an application. And if they don't pass the project, I will say sorry by buying them alcohol. Thank you so much, Pareno.
Thanks so much, Mr. Kamau. Thanks so much. So just not to sum it up, very true. So what I could say is what they said is true. There are two different things: practice and theory. What you're touching KSL and what you are what you'll do out there in practice. But the key take I can give you is for your project works. We didn't want to delve into the project work because the problem with project works is everybody has diverse answers on how you approach something. Even two lecturers will disagree on a particular point. For your project work, the biggest advice I can say is know your lecturer and do exactly what your lecturer wants you to do. And I can give you this example. When we did our civil litigation project work, the issue was two. Should we approach the National Environmental Tribunal or should we approach the Environment and Land Court? So the first one is, should we do some, I can't even remember what the document, the pleadings were, some notice of something, or actually a notice of appeal in the National Environmental Tribunal, or should we do a constitutional petition by going to the Environment and Land Court? So that was a task we were given. That was the assignment we were given in civil litigation. For me, I went to the National Environmental Tribunal because of I had my own reasons. I had case laws, I had everything to support and back it up and all. I chose to do a net. Others chose to do the ELC. So the only difference is who will be marking your project works. For us, the lecturer who was marking our project work was Mr. Mongari. But during class, I raised my hand and I really tried to persuade Mr. Mongari on how the right forum was to be the National Environmental Tribunal and not the ELC. So I raised very good arguments. I brought a Supreme Court case that would handle that issue. I brought a Court of Appeal case, and I even brought a High Court case. And I explained to her, and she was considerate enough to consider and see that we have a plausible argument that the National Environmental Tribunal has jurisdiction on this thing. But then everybody in Herbert's class who did net, like let's say 90%, who went to the National Environmental Tribunal and not the ELC, they got 10, 11, 8, 9. It depends on the lecturer. I will advise that you ask the lecturer in class, what they expect. If you cannot bring that question directly, but cheza kanini, and then try and ask them what do they want and then do exactly what they want. Now, on the issue of criminal litigation, there's a judgment by Justice Lesit. And I remember last year in Simiu's classes, we raised that issue with Simiu. And Simiu said, I don't agree with Justice Lesit. But you see, the thing is, if you agree or you don't agree with the judge, once a pronouncement has been made, that's law. Yeah. So Justice Lesit said that the applicant ought to have filed a petition in this matter as is practicable. So she refused the issues of chama summons and so forth, of giving her own excuses and reasons. She can get the judgment. I can type down the citation and send it to the class group. But she said you ought to have done a petition. At the same time, it's not injurious. In practice, what Kamau was just saying, you'll find somebody going via petition, you'll find somebody going via chamber summons, depends on what you're looking for and what you're going to get in the courts. It doesn't matter. But now for the examination purposes, I will advise that you raise this case law maybe with the lecturers and then see what inclination, to what side are they inclining to. If they're inclining to a particular side, do whatever the lecturer wants, because they're the ones who are marking the paper. That's the best advice I would have given you.
I agree with you. That particular question, and you can concur with me and Mr. Kamau, all of us did the same civil question, the 2,000 of us, the 2,000 plus of us. And you realize that we were in the same class C. We argued that we needed to approach the net tribunal, I think in consonance with the class A. But you look at what their lecturer wanted was different from what our lecturer, Ms. Mongari, wanted, which was also different from what class B which was supposed to, I think they were supposed to do an ELC petition. So my advice to you, because you might be doing the same question across all the students, I think you need to, mjanjaruke, you see how you ask the lecturers, maybe change, give a particular scenario which is different and distinct from the project work, and see how they react to it. Because at the end of the day, you need to pass KSL, and these are the same lecturers who will be marking your papers. So you will be marking, the cards, which are the projects. So what you do, Mr. Philip, maybe you are being taught by a different lecturer who writes a petition. So just go and rephrase the question, change a bit, the nitty-gritties of the question, see how he reacts to it, see how he answers it. If he gives, maybe a petition, answer it, because, it's what the lecturer wants, not what you think you know. So just see how you maneuver. Maybe you are right, but in what the lecturer wants, at the end of the day, you must pass KSL. That is the argument. You must pass KSL. So whether the argument, and one of the contributing factors to you passing the KSL is the lecturers. So see how you approach your teacher. See how he or she answers the question. Kama atasema ni petition, then just do a petition. Even if you feel, I need to do a chamber summons or a notice of motion, but obviously habeas corpus is by chamber summons. So just see how you maneuver. KSL ni mjanja tu. So ask him or her the question, see how she reacts or he reacts, the answer she gives. That's all. Thank you.
So, Mr. Pareno, if I can make a brief reminder.
Okay.
I think we had a separate teacher. I think you were taught by Madam Mongari, and class A was taught by Madam Oduon. We as lawyers, we understand that I think I should have asked Madam Veronica this question about the doctrine of exhaustion. The doctrine of exhaustion, that when you are confronted with an issue or a matter, where do you go? Which is the first court of which is the court of first instance? We can be doing an issue and we go to a tribunal. Yeah. So in our project question, that question was the first tribunal or court of first instance was the Environment Tribunal. But remember what our teachers say, that Madam Mangaro said that you can go to
what she said.
Yes, our teacher also, I think she invited the chairman of that tribunal, the net. So we, as foolish as we were, we didn't consult. We even didn't think. We just went and drafted application in the National Environment Tribunal, avoided what Justice was it? I think Pareno has given the judge. Who was the judge? That issue. So,
Justice Lecit.
Yeah, so you just do what your teacher is telling you. If Mr. Omosa is telling you, do a habeas corpus, don't go and do petition. If Madam Odor is telling you, do an application at the National Environment Tribunal, just do what for purposes of the project. But when it comes to exams, you can even do those two exams. You can also do those two applications. Like Noah here, Noah was a mad person, was doing two applications in the one question, so that the examiners can choose if they want.
I did a fail and a JR in the same question, so that they can see what of math.
So for exams, you have a limit to do what you want, but for project, it's on the hands of your lecturer. And I can beg you people, when it comes to commercial, if you are taught by Sam Indolo, do exactly. You see those butterflies, you can also even draw them in your project if it is possible. Because it is for this, the purpose of this meeting is for you to pass, guys. So do what you are asked. I think Mr. Pareno, I can retire and I can join
that's
you
fine.
later in the near future. Thank you so much.
Yeah, we're even about to finish. We can take the question from Ngatia, then Muturi, and then you close it up. Then Gashil, then you close it up. It's getting very late. Ngatia? Is Ngatia in? Now, Muturi?
Yes, thank you. Thank you for the opportunity. And I have a question still on petition, and specifically on the civil procedure project work. And in our firm, we are faced in a dilemma between a JR and a petition. And the reason is because if I can give brief facts of the case, of the project work, the purchaser, the company bought land from another company. The transfer was done. The company did all the due diligence, and they ascertained that the seller was the actual or the registered owner. And then they developed the parcel, and then after some around 5 years, they received a letter from the land registrar indicating that there were some irregularities that attended the acquisition of title by the seller. That it was back in around like 20 years ago, before 20 years ago from the date of sale. And now the client, the director of the company, comes to us and they say that they believe that Kenya has a constitution that protects property right, and they say that they have heard from other people that our firm is so well in protecting constitutional rights of clients. So in such a scenario, for us, we felt like the issue there is an administrative body that acted ultra vires, or even the buyer was never given a chance to be heard before the registrar made his decision. So that's why if some people were so much into JR. But then on the other hand, on the last part of the question, we felt like it's like guiding us now to do a petition, because it's indicating that the client believes that in Kenya we have a constitution that protects property rights. And they also say that the client also say that he has heard that we have a reputation of filing such constitutional petitions. So can you kindly advise on, according to you, which position or which kind of an application would you make?
So in that circumstances, it just depends on the question, and back to what we said on just maybe what the lecturer wants. But right now, if you read article, let me get my constitution. If you read article 23 of the constitution, article 23, in any proceedings brought under article 22, the court may grant appropriate reliefs, including a declaration of invalidity, etc. So an order of judicial review, yeah. So you could seek for the same judicial review orders in a petition. You could seek for the same judicial review orders in a petition. So how will advise this? And I don't have an answer for this, because it's project works lecture. Every lawyer has a different answer on how to pertain things, and I may say something that maybe the lecturer doesn't agree to. But you will have to read the Constitution, Article 22, 23. You are permitted to seek for judicial review order. So if you want to quash an order, certiorari, you can look for it under a petition. If you want an order of prohibition, if you want an order of mandamus, you can look for it under a petition. And in the same petition, you will also allege that, your rights have been infringed, to be specific, Article 40. You will also include Article 47 on fair administrative action, because, there are those things, right to be heard, be given reasons for a particular decision, etc., etc. Now, that's it. And there are judgments, high court judgments that are saying right now, the way it's shifted to the way these things are shifted towards, judicial review shifted towards, you can do it via a petition. Yes. And even there's a recent judgment that said, I'll get it for you. Can't remember the quotation very well. But when I was reading it, said that you do not even need to seek for leave stage. The aspect of judicial review, to first seek the leave stage, file those documents, then now later on file a notice of motion and something of the sort. That's for JR. Where you're looking for mandamus, certiorari prohibition. Yeah, that is for judicial review. But remember, at the same time, a judicial review won't be a completely exhaustive, because what are you looking for? If you look at the wording of Article 23 of the Constitution, you'll also be seeking for a declaration of rights, that the court to declare that this person infringed upon Article 40 and Article 47. The question would be, and I pose it to you, can you do it via judicial review? Can you look for declaration of rights via judicial review? That's the question that I will pose to you to maybe go do some research on it. So can you do it? Can you look for enforcement of rights? Can you look for enforcement of rights under JR? That's something that we'll ask for it. Huh? Yes. Muturi, then Lavins, then you take it up. Muturi, go on. What are you saying?
Oh, I'm saying thank you. Understood. It's well understood.
Yeah. So maybe then Lavins finishes up. So you need to look at it this way. A petition is all encompassing. You can look for judicial review orders in a petition. You can also look for declaration of rights in a petition. But the question is, can you look for declaration of rights or to get the orders you want via JR? Because this person, if I understand well, he wants to say that his rights have been infringed upon. Yeah? So can he get it via JR? That's something you could think upon it. And then also you need to read this case of Anarita Karim in Zeru that was affirmed by trusted, this one, something, Muo Matemo vs. Trusted Alliance Society, Court of Appeal judgment that affirmed the principles in Anarita Karim in Zeru. You need to look at that judgment. Because you see, the thing with petitions, there's an aspect of reasonable, you need to plead the violation to a reasonable degree of precision. You need to plead it to a reasonable degree of precision. So you need to look at that aspect. So can you reasonably plead it via a JR, or will it be, there's a way you need to craft a petition pursuant to the Mutunga rules, or will be a petition or will the petition be a proper way? But in the end result is, if you're looking for an order to quash, you can get it via JR, you can still get it via a petition. That is why I'm saying everybody has his own particular way of doing things. You'll find a law firm which will say, let's do JR. Remember, okay, last year we challenged this thing, what's it called? We challenged the Council of Legal Education because of some exams they wanted to give us. They wanted to give us exams without giving us a particular notice. They did via JR. But you could also do a petition and say, there are some things that have been violated and all that. So it depends with what you want. It depends with what you want, the orders you're seeking, and and so forth. So you have to look at Article 22, Article 23, read those case laws that I've referred you to, and also check case laws on that particular issue. Vince, gone.
So that case that declared that there is no need to seek leave of court to institute JR proceedings, and it declares Section 8 and 9 of the Law Reform Act and Order 53 of the Civil Procedure Rules redundant, is called Felix Kiprono Matagay versus the Attorney General. It's petition number 337 of 2018. It was a judgment by Justice Correa. I'll repeat. So Felix Kiprono Matagay versus the AG, petition number 337 of 2018. So it says there's no need to seek leave while instituting a JR proceeding. So please note that and read the judgment. Thank you.
Yeah, it's getting very late. Who's asking questions? We have Kimunya, Munga, Ngatia, Gasheru. Okay, let's start with Kimunya hasn't spoken. Then we go to Munga. Then we go to Gasheru. Then Ngatia. Ngatia, I'm asking her, but she's not unmuting. Then we go to Ngatia and then Gasheru. Kimunya, you could begin.
Yes, so I don't really need an answer, but maybe it's a comment on that case of Felix Kiprono. So maybe it's just something to think about. But if we are saying that we don't need to seek leave by that judgment, then I understand that the leave state was to sieve out staff, and also the fact that leave acts as a stay. So now if we don't have the leave stage, will we have a stay of proceedings, or how will that happen? So we can say that it's not necessary to seek leave, but how effective is that if we won't have a stay of proceedings without that stage? Yeah, maybe it's just something to think about, not that I need an answer right now.
Yeah, that's a very good point actually. We could even go check order 53 of the civil procedure law. That's a very nice observation. And then now, since I won't give an answer for that also, but then I will ask another question to you guys. So when you're doing a JR, you're looking for 3 orders: prohibition, certiorari, and you're also looking for mandamus. My question is, do all of those operate as an automatic stay in leave stage, or does it only apply to certiorari when you're looking for an order for certiorari? Maybe it's food for thought. You could think about it in that sense. Thanks a lot, Kim. And now we go to Elkanah.
Hello.
Hello.
Solonka, good evening. Thank you. Thank you so much. Also, I would want to thank all of you for this initiative. It's really insightful. Now, I do stand by your submissions fully when it comes to the question that was asked by my colleague Muturi in the civil litigation, our project work. In our firm, we looked at the both scenarios and we weighed them in the sense of what orders are we seeking from the court. So in the petition, it gives you more latitude to ask for more orders than in the JR. Now, I want to add a different twist to the same question, but in a different unit. In this sense, we are looking at conveyancing, whereby in our project work, the advocate was acting without a valid practicing certificate. Now, our lecturer, Mr. Odera, Tony Moses Odera, he was very categorical in the sense that he stated where the opposing counsel or the party acting for any of the vendor or the purchaser, if they do not, the party does not have a valid practicing certificate, is a red flag. And he quoted to us the Ndolo Aya case. Now, the Ndolo Aya case, I'm sure everyone in this platform is aware of the same, was categorical in the sense that that person is an unqualified person. And this, the issue I'm having with this is because this case was in 2009, prior to the 2010. Now, after 2010, we have the case by the Supreme Court that when we were doing our reading, we came across is National Bank of Kenya versus Anajal Warehousing. The case essentially interrogates the position of Ndolo Aya and distinguishes it in this sense. It states the Supreme Court was of the view that, yes, it's true that this person is an unqualified person, but the Supreme Court was looking at it in the perspective, should the consequences of an advocate be felt by their client? The Supreme Court used the approach of there is no need, or it should not be just for a client to suffer the wrongs of their solicitor. And they quoted an English case which had the same wording. So we can see a total shift from the Ndolo Aya, which the case, the Supreme Court was stating, yes, this case is true, and this person should be put forth for disciplinary measures here and all that. But should this client be suffering just because of the wrongs of their advocate? And in so doing, the Supreme Court came to look at the intentions of the parties. Were the parties intending to be legally bound? If so, then that to declare that contract void would be unjust to the client, even though their advocate was in the wrong. So I think I would want to hear feedback from you guys on that, because now the shift from 2009 to 2010 is very huge. And we asked the same question to Mr. Odera, and he vaguely evaded it and stated he had not read the case, therefore he cannot give a specific answer, and he's never returned back on the same.
Thank you for Thank you for that. That's a very interesting thing. Well, the lecturer said he hasn't read that case, and I think it's a locus classicus case. There's the Supreme Court decision. It did away with the former position. So right now, as it stands, the law is, under the Constitution, Supreme Court decisions are binding to all other courts other than the Supreme Court itself. So the position is, if an advocate doesn't have a valid practicing certificate, what will happen is the documents will not be invalidated or declared null and void. The documents will be legal, but this advocate will attract disciplinary measures. Previously, the agreement, the entire documents, the entire conveyancing documents will be held invalid, could not be enforced and so forth. But right now, the position pursuant to the Supreme Court case that did away with it. It was NBK, it was Wilson Dollar, and then now the later case was Anajwe Housing. So it did away with that, and the position, I think they also amended the Advocates Act. Let me check if I can see, supposed to be section 35 or something. Let me just check and confirm. The Advocates Act. It was
Section 34.
34, yeah, section 34 was also amended to factor in that Supreme Court decision. So the documents are valid, but the advocate will face disciplinary action. The documents are valid. But now you also need to distinguish it from a person who's not an advocate doing it. There's a distinction between an advocate who doesn't have a valid practicing certificate and a person who's not an advocate in total. The person who's not an advocate in total, that person, the entire documents will be invalid. Okay, but if you're an advocate, but the only thing you lack is a practicing certificate, what will happen is the documents will still be valid, but then you will attract disciplinary measures. I think that's a very good question. So that's the position right now with law. It's binding now, unless the Supreme Court overturns its own decision. Then we have, who else? Gasheru, then Gitahi, then Gatia. Gatia, you can unmute anytime.
All right. I want to, there's that issue that have been raised by my colleague, Ms. Kimunia Beatrice, the issue of leave, especially into that specific case of Felix Kiprono. And I think the courts did pronounce themselves that leave is not required. But then if you read that judgment, it says that the court is inviting Parliament to make the necessary changes. So until the changes are effected by maybe Parliament, then it means that leave is important. Leave is not actually leave is required. Is that the position? Maybe you can answer that.
Now, okay, I'll go read that thing very carefully again. I read it once, and it did away with the leave stage. I'll do it again. Then the next time we meet up, I'll take it up. I'll put it up. Just putting it right now in the diary. I'll check it out again. So, and that's fine. Huh? I can even post it in the group.
Okay.
Okay, and then you have Gitahi.
Okay, I think actually I had two questions. I don't know whether I can ask before Gitahi asks.
It's fine. Now go on then, Gitahi asks.
All right. I think what it does is that it makes that specific provision or tiers such that if it is not required that you have to seek leave, and then the law has not been changed, it means that the current provision of the law that is in existence, that law has to, you have to seek leave before you commence AR. I think that is that. But you say that to that. My other issue, I think the where you find that the point that is raised by my lecturer, Mr. Mujithia, who specifically stated that if you are the last advocate in court, you cannot leave the courtroom until maybe all the matters have been called out, and maybe the court has maybe either gone for a break or the session is over. So how practicable is that aspect of the law?
To be honest, I'm not so sure because that's something I've heard today for the first time. But you see, it's generally what happens in practice and what is theoretical. People do it, people leave it. I've been in court and everybody leaves. Even during attachment, all the advocates leave and go. So I think it's just there. How will even the courts enforce it in the first place? It's the way we were discussing the issues to do with professional fees. You'll find advocates contradicting the REM order, the remuneration order, undercharging, undercutting, contingency fees, and it's still whatever happens in practice is different from what happens in theory. That's the answer we'll just give. Now, Gitahi, let me sum it up.
Thank you, Solonka. So I just wish to weigh in on the issue of JR, and as Pelo had stated earlier, and he stated the case very well, that you do not require, the leave of court to, file JR, as it was pronounced in that case. And our lecturer, Gad, if you're in class A, he actually mentioned, go and listen to the recording class 23rd of August, this week on Monday. He actually said it. He actually brought it out that there are two ways to approach the court in JR. You can either go by order 53, that is the civil procedure rules, or without leave. So if you go by order 53, you'll have to seek leave. But then with the new constitution, with the 2010 constitution, now that JR is, the orders sought, they are premised under the Fair Administrative Action, that is under Article 47. Then it's under the Bill of Rights, and you do not need to seek leave when you approach the court if you are going to rely on that article. So you can approach the court but most people, the trend has been really to approach the court through that Article 47 of the Constitution. Thank you, Solonka.
Thank you very much. I've actually taken into note. I've taken note of everything that you've said. I'll go do research. I'll read the law. I'll read more judgments, and then I'll get back to you guys eventually. Now, before we sum it up, is Angachi cannot unmute, but it's fine. You could just hit me up via my inbox, then you can discuss whatever question you had. So thank you very much for coming. Mutu, do you have a question?
Yes, kindly let me ask to do up on the question that was asked by Mr. Rikana. In such a scenario where an advocate doesn't have a valid practicing certificate, and he witnesses a sale agreement, and at the time of witnessing, the purchaser and the vendor knew they were the qualified advocate, only for them to realize later that this guy didn't have a certificate. But the advocate only witnessed. Would that sale agreement be deemed as valid or not?
This person doesn't have a valid practicing certificate, yeah?
Yes.
But he's an advocate.
But he's an advocate.
So yeah, you can check section 34B of the Advocates Act. It's saying, notwithstanding any provisions of this act, nothing shall affect the validity of any legal document drawn or prepared by an advocate without a valid practicing certificate. What they're basically saying is, whether you have a practicing certificate or not, the document will be valid. It will be completely valid. The only thing that will happen to that advocate is disciplinary action, but the document, so the sale agreement will still be valid.
But now this guy only witnessed, he didn't attest, he witnessed. So will you pursue the advocate only witnessed? He didn't attest. He witnessed the sale agreement, but we are not told whether he attested. Actually, it's a question. It's a project question. That is it civil? I think it's civil. Yeah, no. Conveyancing. It's conveyancing. We are told he only witnessed. So will you pursue a professional misconduct, because it was just witnessing?
So the thing is, the issue, if it's in conveyancing, it's a conveyancing thing. You don't need to go into ethical issues and all that. If it's a conveyancing paper, I'm sure the lecturer is looking for is the thing valid or not? Is it valid or not? So, and since you're talking about witnessing, you also need to go check section 3 of the Law of Contract Act. Yeah, section 3 of the Law of Contract Act that gives the validity of agreements in general. You can also check the Land Act. Can't remember the sections. This is under section 38 to go. Can't remember it very well. But just have a look at those sections. What are the essentials? What are the validities of a sale agreement? What makes it valid in the first place? And then now compare it and contradistinct it. Yes. Who's talking?
It's me.
Oh, Alex. Yeah, okay, go on.
With regard to that question, see, there's a difference between the usual 3 terms in conveyancing. There is attestation, verification, and execution. They confuse people a lot. When it comes to when you're told that an advocate witnessed a sale agreement, there's no problem with that issue because any person can witness. It's just witnessing. You see, you don't need to be an advocate to witness. So even though you are an advocate who does not have a PC, there's no problem with you if you witness the document because you are a mere witness. But now when it comes to the issue of verification, when you look at section, I think 45 and 54 of LRA, you talk about verification by an advocate. So a processor you have to have a PC. But now when it comes to execution, the issues to do with witnessing, when you look at section 3, as long as said of the Law of Contract Act and section 38 of the Land Act, they don't require an advocate to witness. They don't require a person with a PC to witness. Any person can witness. And if you witness, and of course, witnessing is just signing that you are witness to the purchaser or you are witness to the vendor. That will be sufficient. Thanks.
Thanks a lot for that. I think Gatia can unmute now. She's told me that she's able to unmute. Please go on.
First, I apologize for the microphone issues. Would you mind explaining the difference, that is, if any, between a representative suit and a class suit?
Okay, I'll answer that and then Alex will also top it up. So a representative suit, it's order of the civil procedure rules. You will check order 1 or order 1 rule 8 of the civil procedure suit of the civil procedure rules. Just confirm with that. That one provides for representative suits, and this is where you have somebody instituting a suit on behalf of some of other people who have a similar interest in that matter. So that's a representative suit. A person who institutes a suit on behalf of others who have a similar interest in that particular matter. So you have, like, let's say maybe 20 guys who have a similar interest. Then you have one person who institutes a suit on behalf of those guys. That is a representative suit under order 1 rule 8. Now, a class action lawsuit, I will refer you to article 20, article 22 I think it's article 20. Yeah, article 22 of the article 22 of the Constitution. That's a class action lawsuit. So public interest litigation. You will look at article 22 to be specific. 22(2)(b), article 22(2)(b), it says, in addition to a person acting on their own interest, court proceedings can, under clause 1, may be instituted by a person acting as a member of or in the interest of a group or class of persons. So I will term article 22(2), that one provides for class action lawsuits, or maybe public interest litigation. Then the other one, under order 1 rule 8, that is representative suits. So those are the two distinct provisions that provide for both of them. Then, I don't know, apparently I can't, thank you. I can't hear who else has a question. Just unmute. I've seen Kimani something, but I can't see it via on my computer, my laptop.
Hi, it's Kimani Esther.
Okay, yes, go on.
Okay, I had a follow-up question on the representative suit answer that you've given. Now, when it comes to remedies that you will seek in your pleadings, will you seek them on behalf again of all the parties interested, or how would you basically even how you would explain the instances or the situations that would let me just talk about the pleadings because my head is everywhere and nowhere. How do you then make sure that the remedies that you would seek are for the interest of the person that you're representing as well as other people? I am a bit confused in that instance. Just shed a little bit more light on that. Thank you.
Okay, karibu sana. So I'll give, maybe I can give a hypothetical situation, how the answers then Noah can top it up. So I'll give a hypothetical situation. There is a community, let's say there's a community land somewhere, yeah? And in that community land, the registered members are, let's say 100 members have been registered, and the community wants to divide the parcel of land so that all those 100 members get individual titles. But then there's a class of maybe, let's say around 50 guys who live in that area, and they're like, why are these people not registering us? Because we've been here for a long time. We need to be here. They need to add us into this membership so that we also get a share in this piece of land. So they decide, instead of going all of us to court, we can have one person representing us. And if you check order 20, order 1 rule, the 1 rule 8, it talks about some authority notice being given to all those other people, and there's some form of authority that has been given. So what will happen is, how would you frame it? So in that particular thing, you just want these people to be added into these thing. What's it called? To be added into this piece of into this community land. So how will you phrase the orders? You will just say that all these guys representing and all this number of members, pray that they be included in that list. That's the answer I would have given at the top of my mind. Maybe I could get assistance from Noah or anybody else who wants to contribute.
So, Ms. Kimani, can you hear me?
Yes, perfectly. Thank you. I can.
I asked my younger sister, Miss Veronica, a question of the Syokimau case, and I touched a bit on the issue of that you have raised. So I'll repeat it again so that you can grasp it. So what happens is, and I'll give the hypothetical, or no, it was a real case scenario of the Syokimau case. You realize that a particular company has emitted a lot of gas. People are suffering, some people are dying of what. So what happens is that you realize that maybe around 100 people are affected. These 100 people cannot be listed in the pleadings. So you realize that only they can choose among themselves 2 people who can represent the 100 people in court. So what happens, both in practice and in theory, in class, what happens is that among the documents that are filed in court is a letter of consent. So what you do as Ms. Kimani, maybe you are part of the victims who are affected, or the plaintiff, or the petitioners, or the aggrieved. You list all those people who have been affected. You make sure they sign that particular, consent that they wish to institute the suit, and that you, Ms. Kimani, will be representing the 100 people who have been affected in that particular suit. So they make sure they sign such that those people who have signed that particular consent letter or some sort of document, they will be binded by that particular judgment that will be issued by that particular court where you have filed your suit. So any order or judgment or decree or any particular direction issued by that court in respect to you, Ms. Kimani, who has filed that particular suit, will apply to the other 100 people who wished you to represent them in that case. So what happens is that in that particular case file, where you realize that there are 100 people, who are affected by that emission of gas and have filed a petition to the ELC court, they must sign that particular document. Failure to which, if you don't sign and a case has been instituted, then those particular orders won't apply to you. So the solution is, me nor Reda have been affected by that particular gas. Emission of gases, I cannot breathe, maybe my particular sister, me has passed on. So we agree that, oh, Ms. Kimani, go to court, represent us. So you'll come with a letter, we sign, all of us, maybe me, my neighbors, everybody can sign. You go and file it in court. So any direction that will be issued to you will apply to us. I hope this has settled the issue. So long as that consent letter is there that I've signed, me nor Reda, that have been affected by the gas. So if the court gives you, Ms. Kimani, an order, it will apply to me. Feel like if I do not sign, then those orders won't. So the issue is, I have to sign that particular letter or that particular consent. It must be there in the file. Feel like which, if it's not there, then it will be you, Ms. Kimani, who will be affected by those orders. Me, I won't be affected by it. So I think I've tried to dissect the issue.
Yes, you have. Thank you.
Thank you very much. Hey, okay, keep like that going.
Mine is not a question, it's just to give a vote of thanks. Solonka and the team, thank you so much. We're really grateful, and words can't even explain how grateful we are.
Yeah, we really appreciate. Me personally, I do not think anybody should ever charge any student for tuition. And that's seriously exorbitant, and then just taking advantage. I don't subscribe to that school of telling people to subscribe or pay or charge people for tuition. I don't agree with that completely. Because you were there, you experienced the same thing. Why would you charge? And that's why we're going to do it completely for free, and we're not going to charge anybody. It's giving back to society. You cannot say that you're doing pro bono work and at the same time you're charging. You cannot get a client in future and then tell them that you're doing pro bono, and then at the end you tell them, no, well, give me this and this and this. Just do it. However your blessings will come, it's fine. It will. And then in future, I'm sure some of you will be judges, AGs, will interact at that level. And I'm happy. I'm obliged and really happy that my team, Alex, Lavins, Noah, and the others, we are here to guide you, and we'll be here with you all the way. So it's our pleasure.
Yeah, sure. And we wish you guys all the best. In future, maybe I'd want to see, Munge, Andrew,